So this video is about the probate process in Tennessee. Hello, my name is Will Cartwright. I'm an estate planning attorney as well as probate with office here in Murfreesboro, Tennessee. So this video is just going to be for a broad overview picture of the probate process. It's not going to be a step-by-step detailed analysis. I intend to make future videos on each step and go in more detail. But again, this video is going to be more of a broad outlook of what the process is. So the probate process, it starts with a petition. So a petition to the probate court, and really what this petition is doing is it's beginning the process. So one important thing with the petition, it starts these timelines, and there's many timelines that's involved in the probate process. So one, it begins the timelines. Two, very important part of that petition is it's going to, if there's a will of the decedent, then usually the will name who the executor is going to be of the estate. And so part of the petition is it's going to ask the court to approve, the executor of the estate. If there is no will, then laws of intestate succession, so these are the laws that is going to distribute the estate based under the law. And in that case, there isn't an executor. So the law gives certain people the right to ask for it. So that's going to be in the petition as well. And again, you're going to ask the court to approve this person or persons. Now, once that executor or personal administrator is decided and approved, then the court clerk is going to issue what's called letters of testamentary. And this is really the court document that's going to give authority to that person to now access these assets or even access some of the liabilities so that they can do their job, which is administering, really doing accounting of this estate and figuring out what debts or assets, what debts need to be paid, and potentially contest those that are fraudulent or not in the best interest to pay. So that's that. And then the court's also going to issue a notice to creditors. So what our statutes say is it's going to be published in a public publication. Typically it's going to be in the local newspaper, and that's going to be issued by the clerk. Now, one thing that's important with probate estates, if there are known creditors, or the law says reasonably ascertainable creditors, so those that you should know, or at least be able to, as the personal representative or executor of the estate, should be able to find out. And one of the first things that we tell the executor or personal rep is you need to start checking the mail, of the decedent. That's really step number one. Get that mail forwarded to yourself, and that's really how you're going to find out. That's what you're going to find out. Where the bills are coming in. Any kind of financial instruments for assets of the estate, those are going to be coming in the mail. So that if they're actual known creditors, you need to actually serve official notice to them. There's a formal way of doing that, and they have so long to respond. It's 4 months in Tennessee. So if they don't respond and make a claim against the estate, then they have waived any right to do so. Now, again, the other major role is doing what's called an inventory, and toward the end it's going to be what's called an accounting. So, and really in a lot of situations, these formalities are waived. And there's ways to waive some of this legwork that's done by the executor or administrator. And most common way is to do affidavits by the potential heirs or beneficiaries if there's a will, heirs at law if there's an intestate succession. We'll do an affidavit asking that the court to waive these requirements of the estate. So again, there's certain time periods that needs to be done. In Tennessee, really, you're not going to probate in a state under 6 months. So it's not and all actually, most of these are going to be a much longer time period for that, because again, there's a lot of different things that can come up in this process. If there's claims that you need to contest, those are going to be, you need to file what's called an exemption to that claim. You file it with the clerk, and the clerk's going to actually set a court date. And you're going to have you got to give formal notice to the creditor, and you're actually going to have a little hearing over whether or not the estate should be responsible for that claim. So there's a lot of little things that can come up in the estate, and it's an important role and could have some serious consequences to be an executor or a personal representative of the estate. It could be personally liable if things aren't done right with the estate's assets. Then the court could potentially come against you and ask to pay those particular debts. So we'll have some other videos. It's also very important to know, and this could be confusing, of what's actually the assets of the estate. In a lot of cases, there's a lot of things that are not actually part of the probate process. And for example, life insurance. If there's life insurance with the specific beneficiaries, those are not part of the probate process. So those are not going to be divided. Those funds are not going to be used to administer in the estate. And a big point of confusion in a lot of cases is real estate, whether real estate's involved in this process or not. And we'll do another video in the future on the real estate and how to properly administer the real estate. So again, this is just a overview of the process, and hope it was helpful, and appreciate your time. Thank you.